My role is limited here to introducing the moderator, which is going to be Brandon, who's our journal editor and has been working with this process, worked with the peer review, and is actually going to be handing the articles off to the next board and graduating. And I guess I just told Lance that Brandon is a Yankee fan, and he's aimed back at New York. So there are some things that have a happy ending, I guess. So far, so good, Brandon.
That's right. Thank you. Very quickly, I would like to recognize certain people without whom this would not be possible. Specifically, Wendy Rice. That's her. You all. He was absolutely wonderful. Professor Fairfield, too. He was amazing. And Professor Restatement, our fearless leader up there. Thank you so much. When I was named editor-in-chief, Professor Restatement, how our process works, submitted a proposal for me to review. So I looked over it and I sent it to the entire board. And it has everything to do with the third restatement of Restitution, Unjust, and Enrichment. I'm saying I had a great contrast professor, Professor Calhoun, who did touch on those topics, but we didn't really get into the depth that clearly the restatement does. So I read through it, I sent it to the board, I said, let me know your thoughts. And they all sent their thoughts back saying, this sounds fascinating. I don't know how many people will get the show, but it sounds fascinating. So our next task, Professor Fairfield and I, is to go to Professor Restatement. Okay, we love the idea. Now, how much is it going to cost us to do it? So I met with Professor Restatement briefly, and he goes, $100,000. He's trying to teach me what unjust enrichment is here. $100,000. That seems a little unjust. Is someone being enriched? And I think maybe he just might have taken some of our funds and he put it toward the marketing degree with these beautiful posters we have going around. So maybe there is a little unjust enrichment here. So I'm going to have to look into that. Every week, my mother gives me a phone call on Monday, and she asks me, what are you doing this week? So this past week, I go, well, Mom, we're having a big symposium. We're discussing the Restatement third on restitution and unjust enrichment. And I'm very excited about it. And, of course, there was a silence for about 30 seconds. I was like, wait a minute, how can I relate this to her? So I said, Mom, big Temptations fan. I said, Mom, this is equivalent of you going to a concert to see the Temptations. I go, this is what we have. It's going to be... And she sat there and she said, I understand, this is going to be a great show. And we have put on a great show for you today. I think everyone in attendance. And I think now we're ready to sing My Girl with our panel here. We have a great panel. So I think we're ready to sing it. I'm going to introduce Dean Bartlett, who's the Dean of Emory, and Professor Weaver, who is a professor at the University of Louisville. And they're going to discuss the BP oil spill. So we're excited to have that. After them, we're going to have Professor Kovacic, who is going to discuss cohabitance, restitution, and then finally we're going to finish with Professor Rogers, who's going to discuss indeterminacy and the law of restitution. So, be part with Professor Weaver.
Thanks, Brandon. And I'm not unjustly enriched at all. In fact, I'm a really cheap date. I didn't even stay at the hotel. We've still got a house here in Lexington, so we're spending the weekend here. We always try and get there when we can. So this was a great excuse to be back in this wonderful law school. And my thanks to the Law Review, to Doug, who is such a doyen in the whole restitution drive, to the Law Center, for its sponsorship of this, and of course to the ALI. It's a wonderful opportunity to get everyone together, really to celebrate this culmination of the restatement on restitution. Congratulations to Andrew for just a superb job over these years. Now, there's another restitutionary aspect of my being here. Above here is the Dean's office. It's right above. And for my last semester here and part of the summer, they were redoing this courtroom. So I had jackhammers blasting, all sorts of plumes of dust issuing forth from the back. And so at last I get to stand in the room that was envisaged when I was in the planning process and we started the construction process. And I must say it came out rather well, and I can tell you that windows at the back were very consciously put there. We wanted really light and air to come into this, and you also get a view of George Washington on top of Washington Hall, if you've got the right angle there. So something of inspiration for us. Now, this is Restitution at the Cutting Edge. I don't know quite why we called it that. Perhaps it was to try and stimulate us at the end of the day. And I know the other papers will be cutting-edge papers. Ours is cutting-edge, I guess, in respect of two things. First of all, it sort of refers to those big shears that we're attempting to cut the pipe, you'll remember, that didn't cut it quite well, and perhaps our paper won't cut it quite well. And there'll be oil gushing forth as a result, and it's also recent. And when Russ and I sat down to do this, we knew it would be recent. But the fact is, nowadays, if you have your radio tuned into NPR to wake up in the morning, every morning you wake up to National Public Radio, there's something new on BP oil spill. So it's new in that sense. So you probably remember all of this, but here you are. I can't do Victor's, Victor always does such a great slideshow. It's not up to your standard, but this is to renew your memories on these things. So here you are. These were the days in which the things looked okay, but there, see those clouds on the horizon?
Slideshow mode.
Who would know? Well,
But that's too sophisticated.
no, it's too sophisticated for me. So here we go. So, and then the explosion occurs, and there's a very good piece in Fortune magazine that really analyses this very well: the systems failure, the whole failure of the industry and BP in looking at all of this, and the Swiss cheese, they call it, which eventually collapses the whole thing, or holes in the system, as there will be in the legal response. And the collapse, all of this is a metaphor of what will happen in the law. More collapse, the surface all on fire, down below. Here are the waves after back to the surface, and that rather ugly waves. So now we're all acquainted with it. So what? How did Russ and I come to this? What did we do? Well, we wanted to look at the response in terms of the compensation scheme that was set up under such pressure. You remember the politics around this, the fact that something had to be done, the Obama administration being blamed for so many aspects, having to come up with a solution, BP itself attempting to respond, but not very well at times, as seen by some of the players here. Hayward, want my life back, you'll all remember that. And then he's doing anything he can to rectify the situation, even praying, and then he's sailing, into court sailing after he get his life back. And Ron Emanuel, or now Mayor Emanuel, says he's got his life back. So, how did he, and there's the president looking concerned on the beach. So, this is quite a cauldron, really, when you have a look at it, for putting something together in a compensation scheme. and how was it to be done? How was BP to staunch all of this bad publicity, all of everything that was happening to its corporation as it was reeling? And you know that this was cobbled together with a $20 billion fund to be set up, called the Gulf Coast Claims Fund. Now, in setting this up, the drafters should have had a look at Andrew Cull's work, I should think, but they didn't. They should have had a look at some trust law quite closely, but they didn't. To give you a sense of how quickly things were breaking. So it was just last November 24th that the emergency payment aspect of this was over, and then we went to the phase where final payments could be made, and the protocol was set forth for that. Then just early this month, Judge Barbier in Louisiana, the federal judge who is in charge of the class action, in a suit brought by the plaintiffs' lawyers for the class action. This is the district court that is to monitor the class action. It's interesting reading the pleadings, because the pleadings from the plaintiffs' lawyers say that Ken Feinberg is crawdaddying. Never seen that verb before, actually. And, I suppose some of you have. Presume it means that somehow they're crawling along in the mud at the bottom of the dam or something like this. Anyway, they're crawdaddying, so that Ken Feinberg is claiming that he is independent when he is not independent of BP. He's being paid by BP. There are other entanglements with BP, and that he should not be going out to claimants saying, I am independent. Then, a few weeks ago, it was announced that BP had come to a settlement with a claimant for $10 million. We don't know who the claimant is, and Ken Feinberg didn't have any details of it. This is money, this is $10 million, which is clawed from the fund, from the $20 billion fund. Again, seeming to say that Ken Feinberg himself, as the claims administrator, hasn't got full control of this, the corpus of the trust funds. Then we have the statement from Ken Feinberg that said $20 billion is really much more than enough to pay the claims. We should be able to pay the claims out for no more than $10 billion. And this is going to be this will really flow from the fact that all the microbes in the warm water in the Gulf are really gobbling up all of the pollution. So the claims will go away fairly quickly. Then, as you woke up the other morning, you may have heard that no, scientifically there's some questioning of all of this, and that Ken Feinberg has been very much criticised for the payments that are too small. The claimants are saying that he's being far too mean about this. And that it's about time he started paying up. The states too, the politics of it say should pay up, and there's a real political economy here, because the idea is that there's a lot of money and this could be spread around, and the states themselves could benefit from some of this money that is being paid out. One thinks of the tobacco fund, one thinks of how the tobacco funds were used in the end by some of the states. So let's, and Russ and I then looked at the compensation scheme. This was really jerry-rigged under this tremendous pressure that was brought to bear. Ken Feinberg was set up to run the scheme. There's a trust fund. The trustees are very trustworthy trustees. My old colleague from Vanderbilt days, Ken Severud, is one of the trustees of the trust fund. Other notable, worthy, reliable people there. Citibank is the trustee to pay this out. And of course, Ken Feinberg himself is tremendously trustworthy, having run the 9/11 fund so well, so efficiently, and with great fairness. He came into this with a great reputation. He came into it with a 9/11 fund. He said he wouldn't take a fee for it. So it's a great deal of credibility that Ken Feinberg brings to the exercise. Ken Feinberg, of course, has been criticised severely, and one can understand this. Because what's going on here, in terms of engineering a compensation scheme, is that any compensation scheme is going to have to overcome agency costs. It's going to have to be a scheme that engenders trust. You've got claimants who are going to say, we will stake our claim with you rather than rely upon the federal class action that Judge Barbier is overseeing. So what you've got here is a clash between, on the one hand, this compensation scheme, ad hoc, put together, and on the other, a class action that is, as you know, put together under the federal rules. And both have quite severe agency costs. And we know that when you look at the way in which you run complex class actions, the incentives that plaintiffs' lawyers have, of course, are problematical. This is why Judge Barbier is a court that is trying to monitor and supervise this, to try to reduce the level of the agency costs that are inherent in running any of these, in running one or two compensation schemes. So this is actually a heuristic that was put together by Armor Hansman and Krugman on agency costs, legal strategies, and enforcement. And it's a nice summary of the issue. Now, the problem is, of course, how do you devise mechanisms which are going to encourage claimants to come into your tent, to come into your compensation scheme? And there are various ways that you can look at this. You can look at ex post standards. Justice might be an ex post standard that has a mixed reaction. There are various rules, both at entry, both at exit. There are regulatory rules that the government might want to apply. There are private liability rules that also will do it. And of course, it's the private liability rules that we may be interested in, as well as here the whole dynamic of having Ken Feinberg as the claims administrator. So his reputation is awfully important. The reputation of the trustees here is awfully important. And the more that is undermined, the more that there may be an exodus to the class action. So what Russ and I did was to have a look at how some of these rules may apply. And it's interesting taking Andrew's point during lunch, where Ernie Weinrib said that restitution was private parts of private law. This really looks at restitution and the rules of restitution, rules of equity and so forth here that should have been thought of, where the structure could have been more effective if the rules had been adhered to. That could have served this lowering of agency cost issue. It could have reduced agency costs so that this would have been a more effective compensation scheme. And this is not only a once-off. We're going to have these compensation schemes set up for these large-scale compensation issues in the future. And one hopes that in doing so, to the extent that restitution rules can actually lower the agency costs, can lead to a bonding whereby claimants and the claims administrator here will have undertakings which will bond them to performance, will in fact serve this purpose of lowering agency costs. Russ, I've used up most of your time, but do you want to say a few words?
30 seconds.
Andrew, good work. And I'm pleased we're doing this in honor of all the work you've done. Doug, a terrific job putting this together. It's interesting, when David and I started work on this, we were thinking about this completely differently. Because we were thinking about it from the sense that $20 billion, is that really going to be enough? Because when you look at the claims across the Gulf, you see resorts in Florida and many other places. We just figured there wouldn't be enough money. And as we started thinking about it, then we started thinking about, well, suppose they pay this person and not that person. Could there be a restitution claim that comes in here? Could there be a claim against the fiduciary for breach of fiduciary obligations? The obvious examples are the ones we put in our paper dealing with fraud. If you've got a hotelier who submits a large claim for loss of business, and in fact what we find out is his hotel was down for renovation, so he just defrauded Feinberg and Feinberg paid. Well, you might be able to claim, certainly Feinberg can claim back against that person. We looked at issues like, what if people make subsistence claims and those sorts of things. Lots of those issues came up. In the final analysis, David's absolutely right. We went in an entirely different direction. Because I don't know if you heard, day before yesterday, they indicated that Feinberg had only paid out $3.5 billion. So basically, it's not paying out very much. And you pronounce it Barbier or Barbier?
I pronounce it Barbier.
Barbier. Okay. Judge Barbier's order requires disclosure to all the claimants that he works for BP and that he's under their direction, which of course is pushing people away from accepting settlements. There was a report 2 days ago which indicated that some people were opting out of the system in the sense of taking final payments and opting instead for these interim payments and just submitting ongoing interim payments. So I think both of us came to the final conclusion that it might have been better had we simply gone with trust rules and tried to use other common law rules, because the current system, I think, is going to push too many people into the class action litigation, and that's got all its own cost, and it's got all its own consequences, and therefore I'm not sure that as David started with, the haste with which they put this together is going to serve the public well.
Hello, I'm delighted to be here, and again, thanks everyone for putting this together, for putting the restatement together. My topic is on a section that was somewhat controversial that entered into the restatement third, which is section 28, allowing cohabitants explicitly, well, not allowing, making it explicit that one cohabitant can have an action in unjust enrichment against the partner who takes off with the assets. And before I talk any further, I just want to say what's in my paper is that watching Andrew put this together, I was in awe of the gargantuan task. As everyone knows here from this conference, Restitution is a very complicated area, and people have specialized in certain parts of it. He had to specialize in all of it. He has to know it all. And he also had to work with the committee. He was kind, he was patient, he listened to people, he skillfully analyzed and drafted, and to the extent there's any criticism of the restatement, it's from the committee members, not Andrew. One of the reasons this section was deemed controversial is because the idea that restitution is too wide, too much uncertainty. And people have used the John Dawson's jump off the dock statement to say he thinks it's too wide. Well, 25 years ago, well, 1983, that's more than 25 years, I wrote a piece where I said that a statement by Dawson is out of context. Unfortunately, to my chagrin, I discovered it's not on Lexis. So, but if I can just read a minute, he says, from the record it appears that a general principle prohibiting enrichment through another's loss appears first as a convenient explanation of specific results. It is an instrument for quite practical and intelligible purposes. Yet, once the idea has been formulated as a generalization, it has the peculiar faculty of inducing quite sober citizens to jump right off the dock. And he says, this temporary intoxication is seldom produced by other general ideas, such as equity, good faith, or justice, for these ideals suggest their own complexity. He says that unjust enrichment and restitution make people think that it's going to be mathematically simple. So I think what he means by jumping off the dock is people think it's going to be simple, and it's not, so they jump off the dock, because they don't want to cope with the complexity they think shouldn't be there. So, first of all, I don't think this section is too broad. Secondly, it follows the methodology of the restatement first. I don't know if Andrew knew he was doing that or not, but why is this whole topic important? Let me give you the facts of one particular case in Wisconsin, Watts v. Watts. Watts and Mr. and Mrs. Watts held themselves out as Mr. and Mrs. Watts, but they weren't. They weren't married. But they had 2 children. She lived with him for 12 years. She did all the housekeeping, cooking, and so on, and took care of her 2 children. And then it ends. And his estate, during those 12 years, increased by $1.5 million. So she wanted something. Would she be entitled to it? Well, if it were 1888, absolutely not. In 1888, a court from Maine says of cohabitants, the parties were living together in violation of the principles of morality and chastity, as well as of the positive law of the state, a relation to which the court can lend no sanctity. The services rendered, as well as the money furnished, she had lent him money, were in furtherance of the continuation of that unlawful relation. The law will imply no promise to pay for either. If there had been an express promise for such purpose, the court would not enforce it. So she gets nothing, he gets everything, and of course he wasn't illicit, right? It's just her. He's not immoral. As you can see, this makes my blood boil. So the restatement first adds a section allowing a cohabitant to bring a suit. They do it under mistake and fraud, and they do it for putative wives. Putative wives are people that think they're married, but their husband has deceived them, and they're not married. In doing this, the reporters, C.B. and Scott, said, there are a number of cases that don't allow this, but we will allow it, and we will follow the modern trend. So that's what Andrew was doing, following the modern trend. But what was modern then is not modern now. Now, I also teach sex-based discrimination, and if you want to see everything I know in 3.5 pages in my paper, please read it. Also, I do have to make a caveat. There are some mysterious formatting problems, and one of the footnotes says error, make copy only. I don't know what it is, but my footnote really is cited properly. So at least. Now, notice that the restatement first only dealt with wives who were deceived. So there's a case in 1937 where a woman and man are living together. Everyone thinks they're married. Their family, everyone, the community. By the way, in all these cases, they tend to file joint tax returns, so maybe that's some fraud on the government. But anyway, they don't address that. He dies, and she wants something from the estate. He dies intestate. Well, the court says, it is well settled that a woman who knowingly and voluntarily lives in illicit relations with a man cannot recover on an implied contract for services rendered him during such relationship. Not only does the relationship as husband and wife negative that of master and service, but such cohabitation be in violation of principles of morality and chastity, and so against public policy the law will not imply a promise to pay for the services rendered under such circumstances. Once again, no mention of the man's role in this. So the modern trend, courts started allowing cohabitants to recover. And the rationale was that these are two equally illicit people. Why should he get everything and she get nothing? Doesn't that mean he's unjustly enriched? Now, there were still some cases going on that didn't allow this, and as late as 2004, a court in Illinois reaffirms the reasoning of the Court of Illinois, which denies a cohabitant woman recovery, by saying, wrong page. Well, I'll skip the reading of the quote, but they again say, illicit, immoral, no, we can't let this woman recover. That case was 1978. It's reaffirmed in 2004. But there are other cases coming that say, yes, they can recover. So in adding Section 8028, Andrew and the committee and the Restatement Third have done just what the Restatement First does, which is follow the modern trend. And this modern trend is different than the modern trend in 1937, but it's totally appropriate. I want to read a quote from Peter Linzer from an article he wrote 10 years ago, Rough Justice, which I think supports this. He says, speaking of the presumptions about gratuitously provided services, in other words, you're in the house doing the housework, that's just because you like it and you feel like it and you give it as a gift, and meretricious relationships, these illicit relationships, he says, one thing that should be apparent, but isn't to many people, is that both these rules are heavily loaded against women. Women usually provide services within a household, and the meretricious relationship ban will almost always leave a man with happy memories and a woman with nothing. Well said. So my, no, I get 10 minutes. Am I doing 20? 20. Okay, so I have to be quick. I'm skipping the part of the paper that says how wonderful this section is. So you can read that too. But then I say this is not enough. And what did Mrs. Watts get from Mr. Watts? The estate went up to $1.5 million, but the court doesn't know what to do, and they say, well, let's do the reasonable value of her services. And how do they measure the reasonable value of her services? Well, he had written a will giving her 10%. So they say, okay, 10% is after some exclusions, $113,000. So about $10,000 per year. And she had given up her nursing career, so she also had these opportunity costs. And I think that opportunity costs should be measured in reasonable value of services, because reasonable value of services in a business context, someone who does a service is charging what they would charge and taking into account all their opportunities. Someone who's working as in a home for someone else, it's not a business relationship. It's not, they're doing a financial decision and making all their opportunities work out. There's another part of this restatement. It's illustration 11. Now, I tried to get Andy to keep it out, but obviously not very persuasive. In that case, it's Maglica v. Maglica, I don't know if I'm pronouncing it right. She and he lived together with the same names for 20 years. He ran a flashlight company. Among other things, she came up with the idea of little colorful flashlights. They called it the Mag Light, and it took off. He, after 20 years, they split. His company, since they've been together those 20 years, has made hundreds of millions of dollars. They go to court, and on the unjust enrichment theory, the jury awards her $84 million. Well, the judge who reverses that says, it is one thing to require the defendant be benefited by services. It is quite another to measure the reasonable value of those services by the value by which the defendant was benefited. Well, first of all, I think that's the opposite statement of what we talk about in restitution. Secondly, the idea that she should have made a contract seems to me somewhat strange, and that, well, this would be the same in any other context, but in any other context, I think someone would not enter into this, work for this company with the idea that, yeah, we're making millions, but you can toss me out of the business at any time. I don't deserve anything except maybe a little salary. Now, in illustration 11, Andrew does put a very generous salary of $1 million over what she's done, but it's still hundreds of millions. Also, the idea that this man may be an innocent recipient of unsolicited services, I think is not right. First of all, he accepted them for all these years, so he should be stopped. And secondly, some of the courts have said, well, this may discourage marriage because it enables the men who are cunning and sly to leave when they feel like it with all their assets intact. So for these reasons, I will end. I think Section 28 is very appropriate, and I would give more remedies. And there are more remedies, too, so read that paper.
Well, thank you all for inviting me and to the Washington Lee Law School for this terrific symposium, the hospitality and so forth. And I want to echo the comments that others have made about what a terrific project it's been, what a joy it's been to follow the project for almost 15 years. I took restitution as a law student from Jack Dawson and been fascinated by the subject ever since. And as other people have said, Andrew's done an absolutely marvelous job. In an earlier piece, I said that this project means that restitution is Cinderella who finally gets to come to the ball. And she, in fact, has her own ball and her own Prince Charming in the role. And what I'd like to talk about briefly here at the end is an undercurrent that runs through a lot of discussions of the law of restitution. And I think we can boil it down to one word: squishy. Look, that has been the rap on the law of restitution since before there even was a law of restitution. If you go back and read Moses versus McFarland, Mansfield says that if the defendant is under an obligation from the ties of natural justice to refund, the law allows an action founded in the equity of the plaintiff's case. This kind of equitable action is to be very much encouraged. And those of us who teach commercial law tend to treat Mansfield as a sort of demigod, forgetting that at the time, and during his life and shortly thereafter, he came in for a lot of scorn and criticism. People said he imported equity into the common law. People said, well, maybe he couldn't help it, he was from Scotland. And all through the 19th century, certainly the end of the 19th century, Thomas Scruton remarked, referring to one branch of what we now call restitution, as the whole history of this particular form of action has been what I may call a history of well-meaning sloppiness of thought. And Candace referred earlier to the quote from Jack Dawson that the unjust enrichment principle has the peculiar faculty of inducing quite sober citizens to jump right off the dock. Now, Andrew confronted the problem right at the beginning of the project, noting the perceived amorphous nature of the subject and that lots of people feel that a purported legal principle that necessarily appeals to a shared sense of what equity and good conscience requires is untrustworthy. And that's something that we've heard lots. Now, my point is not so much whether that's right or wrong, whether it's a good thing or a bad thing, that the law of restitution makes this open appeal to a concept of justice. What I'm looking at is it really any different? Is the law of restitution any more indeterminate than other bodies of law, like its traditional cousins, contract and tort? Now, if we look at the law, the Restatement of Restitution, we find in section after section a statement that in a certain circumstance, someone is entitled to recover if that recovery is necessary to prevent unjust enrichment. And that seems to bear out the charge. It seems to be vague sort of propositions where outcomes turn on some sense of curbstone equities of what's fair. Well, let's turn to other bodies of law. Tort. You want vague? What about the basic principle of negligence? Did the defendant act as would a reasonable man under like circumstances? I never understood that. I mean, I've read T.J. Hooper, and the difference between accident and negligence has never made any sense to me. Maybe that's because I don't teach torts, or maybe that's why I don't teach torts. You want justice? How about the black letter law of conversion? Whether a person's liable for conversion depends on whether his actions so seriously interfered with the plaintiff's rights that the actor may justly be required to pay the other the full value of the chattel. And in the paper I go through the whole restatement, and just endless sections in the Restatement of Torts, which are at least as indeterminate as anything we'll find in the Restatement of Restitution. Take contract. You want vague? How about the law of mistake? Whether someone is entitled to relief from a contract on grounds of mistake depends on whether the risk of mistake is allocated to him on the ground that it's reasonable in the circumstance to do so. That's what the restatement says. That proposition has absolutely no content. It just says yes, if yes, no, if not. Turn to questions of interpretation. If an agreement fails to specify an essential term, what is a court to do? It is to supply a term which is reasonable in the circumstances. Okay? You want justice? Well, the obvious example is promissory estoppel. The recovery is available if injustice can be avoided only by enforcement of the promise. Or how about the obligation of good faith performance? Or how about the concept of unconscionability? Look, if we were really honest, we'd say that the law of contract, the basic principle is that you have to perform your promises unless in the particular circumstances we decide you shouldn't have to perform your promises. Okay. So I don't think there's a significant difference. There's certainly a difference in perception. And that's sort of what puzzles me. Why do lawyers think that the law of restitution is particularly indeterminate? I think some of that is simply a matter of confusion about the word equity. Emily Sherwin's written wonderfully about this. Doug's casebook on remedies does a marvelous job of exploring this. And I think it really comes down to a pun. That the word equity sometimes is used as a simple English language word meaning fair, and sometimes it's used to refer to the complex historical phenomenon that English and American law was developed in two separate legal systems. Now, I've always thought that is an easy way of getting past the confusion. If you just scratch out the word equity, wherever you see it in discussion of restitution, and you substitute fair, if that's all you mean, and you substitute court of chancery, if that's what you mean. The court of chancery stuff, other than the setting of jury trial rights and so forth, is usually not all that significant. The other side, that the recovery is appropriate if it's fair, well, I don't know if that has any content. Go back to Moses versus McFarland. This kind of equitable action to recover back money paid by mistake is to be much encouraged. Well, we could take the word equitable out of that, with no loss of content to the sentence. In fact, the sentence would be even easier to understand. Courts dealing with restitution cases, yes, they're obligated to try to reach fair results. But that's no different from anything else. I mean, can you imagine the judges, the lawyers who are so fond of these vague references to equity, can you imagine them saying in a contract or tort case, this is an action that arises at law, and therefore we have no obligation to reach a fair result. But lawyers say things that are to the converse of that all the time in restitution cases. Now, one way maybe of getting this is if we think a little bit about the relative strength of the ethical principles that underlie tort, contract, and restitution. So a tort, I suppose we could say, well, a person who unjustifiably harms another has to pay compensation. And that is by no means an obvious principle. I mean, Holmes, a century ago, said that as a starting place, we should leave losses where they fall. We should recognize a cause of action only if the defendant can be regarded as seriously at fault. And much of 20th century tort law, I think, can be regarded as a reaction against that proposition. So today, if I manufacture a product that causes a loss, maybe I'm liable for that, even if I manufacture the product scrupulously carefully. Now, we're thinking about by the end of the 20th century, the notion of liability without fault had reached an extent that probably would have shocked Holmes, and he certainly wouldn't be alone. You think of the popular discussion of the legal system. It's common for people to talk about the United States as a litigation-happy society. And the major set piece of that is always the action against McDonald's by the person who spilled hot coffee on herself. All right, now think about the basic problem here. In tort cases, there are no winners. There are only losers. The issue is whether to shift the loss from one person to another person. And if we do so, that's all we have done. We've shifted the loss from one person to another. And I'm not sure we're ever going to come to any satisfactory general explanation of when we should do that. Okay, switch to the law of contract. We could describe contract's basic principle as a person who unjustly fails to perform a promise is obligated to the other party. Well, think about Hawkins versus McGee. I teach contracts, the hairy hand case that we all start contracts with. And the lesson of that case is basically that the doctor, even if the doctor was not guilty of any negligence, may be obligated if the doctor promised the outcome and the outcome was not performed. Now think about that. Suppose that before the operation, McGee had come to his senses and said to Hawkins, you know, I cannot safely perform this operation. I'm not going to do it. He would have been doing the morally justifiable thing, but if we take the opinion seriously, he's still liable for an amount that would place the patient in the position the patient would have been in if the promise had been performed. Lon Fuller noted many years ago, it's a queer kind of compensation to give the plaintiff something he never had. Well, think about that proposition is actually pretty problematic. Take another contracts casebook classic, Neary versus Retail Marine. The Neary case is one about computation of damages, and it basically holds that a retail buyer may be liable for the seller's anticipated profits, even if the seller was able to resell the property. And it's an interesting sort of issue of contract law. But the human dimension of that case, folks often lose sight of. The guy promises to buy a boat, then he gets sick. The reason he's not buying the boat is because he's going to spend his time in the hospital instead of cruising around on his boat. Can you imagine how he felt when he found out that the seller was not going to refund the down payment even though the seller had sold the boat to somebody else? I can imagine his astonishment when he was told by lawyers told by the judge that you don't get back that down payment. The seller gets to keep it as compensation for these lost profits. It's a tough sort of... Now, I'm not saying the outcome is wrong, but I'm saying the outcome in either tort or contract are based on ethical principles that are far from obvious. Compare that with the situation in the law of restitution. Suppose I get $5,000 from a bank that I had no dealings with. I received it by mistake. Am I obligated to return the $5,000? Does it matter that I didn't do anything wrong? No. Does it matter that the bank was sloppy? No. It's a simple instance of unjust enrichment, and accordingly, I'm required to return the money. Now, I've described the basic principles of tort and contract in somewhat unusual terms. I've said that the basic principle of tort is one must not unjustifiably harm another, or that contract one must not unjustifiably fail to perform the promise. Now, we don't routinely make that explicit reference to the underlying ethical principles. And the law of restitution does. And why is that? I think part of the answer may be that the law of restitution can get away with it. Because the basic ethical principle that underlies the law of restitution, the unjust enrichment principle, is just that much stronger than the ethical principles that underlie other areas of law. I think, though, that there may be a simpler explanation for the seeming difference, and that is the role of history. Restitution is the new kid on the block. It's still struggling to gain acceptance and respect. And so we've got that first section of the Restatement of Restitution. Now, there's nothing like that in the restatements of contracts or torts. The Restatement of Torts doesn't say a person who unjustly injures another is obligated to make compensation. The Restatement of Contracts doesn't say a person who unjustly fails to perform a promise is obligated. So why is there the difference? And I think part of that is just a matter of history. Suppose the AOI had been formed at the beginning of the 19th century instead of the beginning of the 20th century. And suppose somebody in 1810 said, I think we should do a restatement of torts. Now, I think most lawyers would have said, what are you talking about? We could do a restatement of trespass, or a restatement of case, or a restatement of slander, but what is this torts subject you're talking about? You really think there's a unified body of law that covers all these different sort of things? And someone might have said, yes, and put that forward. Now, by the time that the AOI was formed and those restatements of contract and tort were put in place, everyone had come to assume that, of course, there's a law of tort, of course, there's a law of restitution, and of course, there's a law of contract. How do I know that? Well, I had to suffer through those courses in law school, so the field must exist, it must be important. The Restatement of Restitution, though, confronts a different challenge. As any number of people have noted, we might well define, we could sort of dispute that, we might well date the origins of the law of restitution with the first restatement in 1936. And so the first task of the restatement, the first task that Seavey and Scott confronted, was to justify the existence of the body of law. And I think that is, in essence, what that first section comes down to. Now, if the first restatement had really been successful, maybe there would be no need for that. And maybe by the time of the fourth restatement, that provision can be dropped. Okay? But for the immediate future, we're going to have to deal with the fact that the law of restitution has up front in Section 1 something that I think you could sort of look at as an explanation, an apology for the existence of the field. Telling lawyers, this is why it makes sense to talk about the law of restitution. But it's important to remember that Section 1 is just a description of the general principle that underlies all the particularizations in the rest of the restatement. The content of the restatement is not found in Section 1, it's found in all the other provisions. Andrews noted that it's very common to find opinions in restitution which consist of nothing more than a citation of Section 1 and then a totally useless laundry list of factors. Right? And I think one of the accomplishments of the third restatement is to say, no, we got to look at the particular scenario, we've got to look at other cases of the same sort. And I think if we think about how we look at that section 1, think of the provision that's common in agreements. Along the lines of headings and captions contained in this agreement are inserted for convenience of reference only and are not to be deemed part of or used in construing this agreement. You might say the same thing about section 1 of the restatement. And maybe even stronger language is needed. I sometimes wonder, maybe the restatement, section 1, should be accompanied by something along the lines of the Surgeon General's cigarette package legend. It ought to say, warning, citation of this section as authority for resolution of any specific dispute may be hazardous to your mental health.
Andy, we have questions?
Two quick points. One, when you mentioned the Neary case, factually that wasn't quite right. There was actually a deposit of $4,000, which the buyer tried to sue to get back, and the response was a counterclaim for lost profits, which was less than $3,000. It turns out that probably it's a bad idea to compensate for lost value profits anyway. I've been on that, but that's a different point. On the BP case, I think you're being a bit unfair to poor Ken Feinberg. I want to defend a little bit. The problem there really is that the existing law on economic loss is that most of these people should recover zero. And that's sort of the starting point. What Ken is trying to do, say, well, zero is too small. And I'm trying to figure out a way to get these people something without having them go to court and perhaps suffer the embarrassment of ending up with nothing at all. So now I'm not quite sure how you deal with that in terms, but the plaintiff's lawyers, the class action lawyers are saying, with a little bit of luck, we can scare these guys into thinking that we're going to get the law changed. And maybe that's where the big bucks are going to come in. But that's a real risk, and Ken has to at least tell these people, the law is that you would lose as of now. You might win in the future.
His problem is, I think, Victor, he's going to lose. That should be an important argument for him, and it should be an argument that the claimants could rely upon Ken in making. Also, there are claims under the Oil Pollution Act, and that's actually a very good memorandum you may have read by John Goldberg from Harvard that was given to Ken Feinberg to give Ken Feinberg some sense of the basis upon which claims could be settled under the Oil Pollution Act and under the common law. And you're absolutely right. Common law claims are going to be very, very sketchy unless, of course, the states change the law in some way. And that's a kind of interesting little wrinkle on this, to the extent that the various states like Florida, which has been so outspoken, would in fact sit down as a legislature and allow claims for pure economic loss to its citizens along the coast. There's a lot to play out here. But in terms of a design of a compensation scheme, I don't think it's Ken's fault. I think it was all put together in such a rush that as a model for future compensation schemes, we ought to have a closer look and get this, have a lot more appreciation of what it would be to get people to trust the fund and the way it's being run.
Professor Walsh?
Yes, I'd like to say thanks to Jim for tying up a theme that I inaugurated this morning. And I think the idea that the problem of indeterminacy haunts all fields of law is a very important one, and it's one perhaps sharpens to a point one disagreement I might have with you, because the one thing about the first section in the restatement that is it seems to me very valuable is that it recollects a principle that Aristotle first established in the Nicomachean Ethics when he talks about the category of equity. Not equity in our sense, but equity in the sense that Aristotle recognizes, as I think every seasoned lawyer must, that there are circumstances where rules in advance do not and cannot do justice, do not and cannot fit And so when Aristotle talks about this category, he actually uses the metaphor of a rule, which is made of lead, he said, which is used on the island of Lesbos, actually, because their architecture was tended to be rounded rather than straight. He said you need a leaden rule in order to take account of that which cannot be measured by a strict rule. And I think the thing I like about this Section 1 idea and the whole idea of unjust enrichment is that I'd like it to be expanded to the other fields of law rather than forgotten. Because what it's recollecting is precisely the idea that there are circumstances that cannot be predicted in advance in all fields of law, and especially in this one. And therefore, we need something like an attitude of openness to new situations. Now, I don't know if you disagree with that or not, but it struck me that your observation about indeterminacy is really raising a larger point that transcends restitution and covers really all of law.
I think that's exactly right. My point is not so much that it is a good or bad thing to recognize explicitly the ethical foundations of any body of law, or to recognize explicitly the fact that we can't always specify entirely the content by determinative rules. But I think an intriguing phenomenon is that part of the fact that restitution has been sort of forgotten stepchild for most of the 20th century gets combined with the sense that, oh, that's that squishy equity subject. I mean, how many times those of us who teach restitution had a faculty colleague say to us, oh, that's an equity subject, isn't it? And you sit there and you try and decide whether to explain and so forth. So you're absolutely right that my point is not that it's right or wrong, but rather that I don't think it's any different from any other field. And the conclusion from that might be that there should be a Section 1 of Restatement of Torts. There should be a Section 1 of Restatement of Contracts that recognizes that there is this general underlying ethical principle that underlies much of the specific content. And there may be instances where the specific rules don't reach it, and we've got to look to that general concept.
Last question, Professor Laycock?
This is a question for David or Russ. I understand that BP presents an incredibly difficult and challenging compensation problem, but I was never quite clear listening to either of you where the unjust enrichment claim is. Occur out of fibrous fiduciary duties or BP's savings? Who's unjust enrichment?
Part of the problem we were looking at was the trust document, and we had a lot of trouble getting hold of the trust document. That's one of the things we wanted to look at and try to figure out what obligations he was under, how he was supposed to pay claims, whether there was a distinction between economic and non-economic losses. There's a whole series of issues that could have come up. So that's really where we were headed in terms of trying to see what he was doing and how he was doing it. But, then ultimately we found out that there's not really much to guide him in terms of discretion, and his obligation really runs towards BP. So that's part of the reason we went away from that analysis.
And let me add, Doug, it's the problem is under the document that there's no really defined priority given as to how the claims are to be paid out. And for claimants, that's an issue. I mean, so if a claim is paid out, say on very dubious causation grounds, then another claimant's claim is rejected or there's less paid, there doesn't seem to be any clear notion as to how that would be resolved in terms of unjust enrichment at all between obligees. And so one would think if you're really trying to design the rules here, you would want to oblige the claims administrator to have a fairly clear list of priorities on which the claims would be paid, to allow claimants to actually be able to make restitution claims, if that's the case, and if they fall short in some way. And the fiduciary obligation is, to use the word squishy, it seems to not really lay any clear fiduciary obligation on Ken Feinberg as he makes these claims. In fact, he beamed himself in at Emory to my last torts class and did a superb job in explaining this. And I said to him, Mr. Feinberg, did you see that there are fiduciary obligations that you owe in this situation? He said, no, I don't owe any fiduciary obligations to anyone. So,
But David, in 9/11, where the statute put very little on him, he then made a very, I think, convincing and, complicated bunch of rules. Why did he say why he hasn't done that?
See, it's very interesting. He was asked the question by a student, do you think that this is going to be an easier exercise than 9/11? And he said, oh yes, this is going to be much easier than 9/11. 9/11 was, now I think emotionally 9/11 was a terribly tough thing to do. And I can imagine that, and he did a superb job doing it, but the complexity of this is so great. I mean, the heterogeneous, every claim is so heterogeneous. There's so many different claimants. It's much more complex situation he faces. And one would think that to have clarity in the way he's going to treat
I agree completely.
what would be the way to do it. And yet everything is fuzzied up. So, for example, there's confidentiality. As he settles claims, he doesn't have to disclose how those claims are settled. And this was one of the concerns with this claim that BP settled. That no one knew against whom the claim was settled. Ken Feinberg said, well, BP settled it, they're entitled to settle it, and they're entitled to take money out of the fund to settle it. Now this is just a very poor signal to all the other claimants here, and the signal that BP has got far too much control in the situation.
And you've got people complaining about the smallness of the amount that they're getting. So, I mean, these are a lot of issues coming up along those lines. So I think greater guidance would have been a big help.
Join me in thanking this.
Oh,